Sham contracting. It's been a hot topic for the ATO and the Fair Work Commission for a few years now. What is it? It's when an employment relationship is disguised as a contractor relationship. It's a risk for small businesses because if the ATO comes knocking and finds that your contractors are actually employees, then you might be asked to cough up their superannuation and leave entitlements. Now, in my experience, employers really want to do the right thing. They're not trying to dodge their liabilities as employers, so how can they protect themselves? It has been difficult. In the past, the courts have applied a multifactorial test where they look at a whole lot of different characteristics, but ultimately what they're trying to find out is what is the true substance of this relationship? Is it employment or is it an independent contractor? That was pretty tricky and complex, but there's recently been two High Court cases where the High Court has said, yes, it will still look at the substance of the relationship, but a written subcontract is going to be really persuasive. So if you're a small business and you've got subcontractors who, perhaps you sometimes worry about whether they might be found to be employees, what should you do? Here's a few things that you should do. You should have written subcontracts. The subcontracts should have some specific terms in them that really capture the full nature of the relationship. They should definitely say that your subcontractor is running and carries the risk of a business enterprise. So that means that they need to have their own tools, they need to have their own PPE, they need to have their own insurance, all of those things that a business owner really should have. Your subcontract should also say that they can only be varied by written agreement. That's because the High Court says that post-contractual conduct is no longer persuasive of determining the nature of the relationship. You should say in your subcontracts as well that there's no guarantee of work for your subcontractors. You can never say that there's going to be a minimum amount of work in a particular period of time. And you should also have a term that says that your subcontractor has control over accepting the work that you offer them or declining it, and also how, when and where that work can be performed within limits. Your subcontract also needs to be responsible for all of their employee entitlements, and as a kind of added risk management technique, you could require them to be incorporated entities under the Corporations Act. That adds another layer of protection. So, do you need help with your written subcontracts? If you do, get in touch. I'd be happy to talk to you about what you need.